This is Antonio Moore coming to you from Tone Talks. I'm here with Yvette Carnell. We had a big decision yesterday. Yesterday we had a big decision. Possibly one of the biggest civil rights cases in the last 30 to 40 years with Byron Allen's big discrimination lawsuit against Charter Communications that he was allowed to proceed with yesterday. We're going to talk about that today. You want to you want to say something to the audience, Yvette?
I just want to say hey to everybody, and I want to thank everybody too. To the people who have kind of reached out to me and helped me with another project that I had. But right now we got to pay attention to what is happening right now in terms of that lawsuit, this big case. So I think we got to pay attention, and that's what we're doing right now.
Yeah, and so it's really interesting because me and Yvette had this discussion just last week where we had this big black wealth discussion. It was more about the issues that we face as African Americans. And so many people saw the statements we said about government as lofty, as unattainable. Government never does anything for us. When you look at this thing historically, that has been the way that blacks have achieved so much progress. And so, this interesting do-for-self mentality kind of rose up out of the 80s and the 90s, and it's left black people in a place where they kind of, to me, can't see the importance of a lawsuit like Byron's. Byron brought a $10 billion lawsuit against Charter. He brought a $20 billion lawsuit against Comcast. And so many people don't know that, but he's actually a billionaire himself. And it seems kind of like these lawsuits must not have any grounds just because the amount is so big and it's a black man bringing them, when in actuality they do have grounds. And that's what the judge found yesterday. Anything you want to say on the topic?
No. I think you should just go ahead and lay it out for him.
Okay. What I feel, we need to start with is the reality of what's happening. Byron Allen is the one, and according to IndieWire, I'll bring that up right now for you, is the biggest producer in Hollywood. This is according to IndieWire, not my belief. For those people who don't know who he is, he's on par with Tyler Perry and with Oprah. He produces many of those court shows that you see on TV and several other sitcoms. But the difference between him and other African-American producers is he owns what he produces. So here you have an African-American man who makes a show, then goes to a network and says, or goes to a cable company and says, air my channel, and I'll just cover the cost. And then I'll make my money on advertising, and you don't have to pay me. I'll get my money from advertising, and you get your money from advertising. The traditional model is I, as a producer, have an idea for a show. I pitch that show, possibly even do the first episode or some section of the first episode. You enjoy it, like it, you pick it up, and you pay me as a producer, but you own the show, and you help me, and you give me the money to make seasons of this show. That's not Byron's model. Now, fundamentally, what he's run into is in trying to get distribution from some of the major outlets. They essentially have leaned on several laws. Well, first and foremost, the First Amendment, and be able to say we don't have to take your meeting. And yesterday's decision puts a big question mark around whether that's okay or not, and allows him to finally proceed to challenge that as not being okay. When you look at where Black America comes from in terms of slavery, and where Black America comes from in terms of Jim Crow, what you have to understand is that we were not allowed first to be part of the market other than as currency. We were a good traded, and then once we were no longer a good, we were not allowed to be equal players in terms of trading goods, and that lasted well into the 70s. And I think for so many of us, that's such a foreign concept because we saw Bill Cosby, we saw LeBron James, we saw Michael Jordan. And as a result, we believe in an America where, not that didn't happen, but that was a very long time ago. And what Byron Allen's lawsuit brings to the forefront is that's not a long time ago, that's today. You want to chime in, Yvette?
I think the context is important. The context for me is so important because we have this whole dialogue going on where a lot of people who don't have access to wealth are talking about how to attain wealth and how to maintain wealth. And the thing that's so important about Byron Allen is that he does have wealth. And what he's telling you is that even with the wealth that I have, I need to go through the court, which is government, to kind of intervene on my behalf, because these people are so stingy. These capitalists, capital is so stingy. They don't even want to give me a crumb. I'm not asking for 25% of a network. I'm not even asking you to come in and pay me. I'm just asking to be on that highway, to be able to drive for myself and get advertising dollars for myself. And they still won't let it happen. So I think what bothers me so much in terms of what Black America is doing right now, African American descendants of slaves, is what we're doing right now is that we're not paying attention to the one person who I can say right now has access to the wealth and who is dealing with the white supremacy that we talk about all the time, and is dealing with the limitations of building wealth. Here you have a millionaire, a billionaire, like you said, with everything that he has, and he has to sue. So, I think this lawsuit is important in a number of ways, but I think this first thing in terms of who he is makes it that much more important. But like the decision, which I'm sure you're going to get into, and how they had turned him away is just incredible.
Yeah, there was actually like lawsuits brought against 3 different companies. The first one was with AT&T. He brought that against AT&T DirecTV, which settled. He ended up with 7 stations. Next one was against Comcast for $20 billion. And actually, a judge actually told him to go back and fix his pleadings. So he's been turned away 2 or 3 times for this pretty much the same lawsuit that now was allowed to go forward from this Asian judge, Judge Wu, today, which and he's now, and also a $10 billion lawsuit against Charter, and not just Charter though, Charter and the FCC. President Obama's FCC basically saying there's no reason that they should have been allowed to have a merger with Time Warner without doing business with African Americans, without doing business that's fair and diverse with all of the American population, so everyone has a chance to use these cable lines. And so when we look at the law he used a law that's been on the books for a long, long time, since 1866. A law that we don't know that's on the books, that we don't know that we needed to be on the books, because those people who at that time were alive knew that white America would not allow Black America to be a fair participant in the market without laws like this. But we haven't been using it. And so I wanted to share with you a little summary of that law so that you can get a clear understanding. And I'll pull it up so you can read along. So what's Section 1981 of the Civil Rights Act of 1866? Shortly after the Civil War ended, many southern and some northern states enacted the so-called Black Codes in protest of and to circumvent the recently enacted 13th Amendment, which prohibited slavery. The Black Codes imposed onerous legal limitations on newly freed former slaves. In response, Congress enacted the Civil Rights Act of 1866, a law generally recognized as the United States' first significant civil rights legislation. That's the law he's using. Section 1981 of that statute confers a series of legal rights equally to all citizens, including the right to contract and to hold and convey property, and states in part, all persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and property as enjoyed by white citizens, and shall be subject to like punishment, pains, penalties, taxes, licenses, and exactions of every kind, and to no other. In 1991, Congress amended Section 1981 by adding a subsection which made clear Section 1981 prohibits not only discrimination in the form of contracts, but also in all aspects of contractual relationships between parties. So what we're seeing is that this law was designed to give slaves a fair footing. Here we have an African American, one of the few African Americans who's been able to achieve the status of billionaire. And if you don't want to accept that, several hundred millions of dollars puts him in the top 0.1 percentile of African Americans regardless. One of the richest African Americans in the country has decided to use this law to not only benefit himself, but also to open a doorway for all African Americans to finally challenge a system that's been hiding behind the curtain of being not being racist for so long.
Exactly, and I think what you said at the end is important. Like, this law isn't about Byron and Byron benefiting himself. Sure, if it goes well, he benefits. But the truth of the matter is, what this lawsuit says, and we'll get into that. But what happened here is that they're basically discriminating against African Americans, and it isn't about Byron. That's what the problem that I have in terms of the conversations we've been having in terms of wealth is that Black people tend to kind of view this as an individual thing.
Wealth, meaning wealth.
Yeah, meaning wealth, and meaning, well, I don't like, even in terms of Byron, like, well, I don't like Byron's ideology. I don't like what he does X, Y, and Z. And you can't see that this is important in terms of us doing business and us accessing capital.
Definitely so. So, like, when we look at the this decision, one of the great breakdowns that I've seen is in the Hollywood Reporter. I'm pulling it up right now for you. It's the title of the article is $10 billion racial discrimination lawsuit against Charter survives First Amendment scrutiny. So what do I mean? What Allen has done is it's a trip because he's one of my friends. I talked to him 2 or 3 times today, not only to congratulate him, but also to discuss how we move forward. But what Allen has done here is he's opened a doorway to allow so many Black businesses to also challenge under the same law. And this is the hardest area, meaning entertainment, and that's because of the historical legislative arc of how things have developed. The case that kind of sets the framework in this area is the Hurley opinion. And in that opinion, what happened was there was a parade, and that parade was basically saying we don't want gays to be part of our parade. And the Supreme Court 20 years ago sided with the parade. They sided with this Boston parade set of organizers and decided that they have a First Amendment right to express the message they want to convey. And this is the kind of like ethos that has undergirded a general latitude to allow many media companies to not do business with Black people. This First Amendment right to display what you want to on your cable line. The problem is we don't have another cable line. So if they're allowed to do that, we only end up with the content that they want us to see. And that's where we're at today. You know what I'm saying, Yvette?
Yeah, exactly. I think the most important part of this decision and them allowing, and Judge Wu, let's point one thing out. This is an Asian judge who's siding on behalf of an African American. He allowed Byron's case to continue. Before that, there was Judge Hatter in the other case involving another cable company, and this judge was Black. This was a Black judge who was 83 years old, okay, and he sided against Byron Allen on a principle that doesn't really make sense. But he sided against Byron Allen. Now think about this. Think about a Black man. This man is probably heralded by local NAACP, Urban League. Everybody's probably proud of him, saying you a Black judge. But what it means to be a Black judge and get appointed to be a Black judge in a lot of cases, not all cases, is that they trust you to be working against the interest of Black people. So we're celebrating people because he's a Black judge, but he just worked against our own interest by not allowing Byron's case to go forward, as this Asian judge do. So it's almost like you have to go to another judge outside of a Black judge to get your stuff, to get treated fairly. The people who are in place for us are in place because the people who own capital, majority white, overwhelmingly white, trust these Black people to kind of stop Black progress.
So, like, focusing in on this Charter case, reading a little bit more into the Hollywood Reporter analysis of it. In the Charter action, Allen's company brought forth allegations not only that Charter refused at 10 cents a subscriber, far below what the cable company was paying white-owned programmers, but also that Charter's executives had made racist comments. For example, Charter's former senior VP of programming, Alan Singer, is alleged to have told protesters outside the company's headquarters to get off welfare. Singer was later let go by the company. That's what the note is. So here you have him, in essence, offering them a better deal than white competition, a cheaper rate, and they still said no. We just don't want to do business with you. And to my understanding, never really gave a clear reason why not. And they don't have to because of the way the First Amendment was decided. The full First Amendment immunization for cable companies over the channels they wish to carry was given by this Hurley decision. And so, Like it allowed for us not to deal with the historical racism of America in this particular industry.
Well, this is the premise. The premise of people who kind of support that we can do for self. This is the premise that if we make a cheaper widget or gadget or make an irresistible product and offer it to white people, they have to accept it, because the premise is money matters more than anything. So if that were the case, though, Byron would have been fine, because he was offering his product cheaper. He was saying, we just gonna do the advertising. That's gonna be the deal. That's what he was doing, and they still said no. So this proves that, like, it's this idea that white people are just all about, that they don't care as long as you bring them something, as long as you bring them a product they can make money off of, that they'll let you in. It's just not true, because they could have made money with this deal with Byron Allen, but they just didn't want to. They didn't want to let the black guy in. They don't want to let the black guy get a piece of the pie. They want to keep the whole pie. And I think one thing that we have to understand when we talk about government is these people want to keep the whole pie. They don't want you to have a slice. They don't want you to stick your finger up there and taste the cream. They want it all. And I think this is what that lawsuit shows. It shows the stinginess and the just, like, we're going to ground you down to dust. That these capitalists, these white owners are doing, and this is happening in a lot of other areas. So I think that's important to note.
Yeah, and I think we have an obligation as black media, as black people, as American citizens, to get behind something like this and really become aware of how important this decision is for your children to have a fair chance. Like, so many African Americans don't remember a time when Jet Magazine and Ebony Magazine and black contractors and black attorneys' offices that had contracts with the state employed black people. Because we need to employ our own people. And somebody would say, well, why do we need government to employ our own people? Because we don't have capital. And so one of the ways that we were feeding ourselves capital was through government being required to share opportunity, because government has ample opportunity. Pension funds being forced to do business with black financial advisors, whether it be a cable company that being forced to allow blacks 10% of those channels. We want 10%. We don't want one channel. We don't have any right now. For those people that don't understand the implications of what's going on now, we have a few channels that are targeted to us, but are not owned by us. Those are BET, Centric. We don't own those channels. TV One, but we do. And we also have a few black people that are part owners. We don't know the level, but we know that these are not former TV executives or film producers. Sean Combs with Revolt, he's a former rapper, a film producer. Former rapper, music producer, but not a producer of content in the TV realm. And then we have Magic Johnson. He's a former basketball player that dabbles in ownerships of other sports teams. But, like, when it comes to somebody who can count the numbers, like Byron, who has a long history in TV, all of a sudden, him saying, I want 100% ownership, I don't need no assistance, it becomes a major problem. I kind of wanted to go further into the decision, read to you some of the actual judge's decision and how he came to his final belief that this case should go forward, and also his evaluation of, like, the history in this area and why things
and mixed motive.
Yeah, and then the mixed motive. So this is a section from the judge. Speaking of Charter's executive, is Singer and Charter's Tom Rutledge, CEO of Charter, alleged arguably racist statements were all that plaintiffs could muster, the court would likely agree with defendant that they were insufficient to satisfy even a motivating factor standard at the pleading stage. But when they are viewed in combination with the several-year effort made by entertainment studios and the viewed most favorably to plaintiffs, continued stonewalling and provision of excuses that do not match up with the defendant's practices with non-African American owned media companies, the court believes plaintiffs have plaintiffs have validly stated a claim under Section 1981. Plaintiffs are entitled to proceed on their claim. And when you think about that, that means I got to read this thing in the most favorable light that's possible for you at this stage. And if that's taken, you like there's clearly an issue here that you have a right to proceed with. You have exactly the issue that they thought about 150 years ago when they wrote 1981. That you're not being allowed to contract. And how can I now in 2015 say, nah, you're not able to use that because they have a right to not have you on TV, like under the First Amendment? That doesn't make sense.
No, it doesn't make sense. And I think what people need to understand is that when you talk about that mixed motive, like it gives you the right basically to discriminate. Like talk about the fact that mixed motive gives you the right to discriminate as long as there's something else. As long as like you had another rationale, there was another motivation. I mean, that's legal discrimination. These media companies, they have the legal right to discriminate.
Yeah, and what she's speaking of now is this section later on, and what the judge kind of says is not just how the First Amendment factors, but also the pleading standards on a discrimination case of this nature. Wu's ruling, after all, also provides some analysis on Charter's proposition that discrimination has to be shown to be the but-for cause of a decision not to contract with Allen's company. Stated in another way, Charter argued that even if discrimination played a factor, as long as it had a mixed motive via other rationales for refusing to carry Allen's network, Charter should be given a pass. In support, Charter pointed to decisions by federal appeals court throughout the country explicitly blessing the mixed motive theory, and a couple of Supreme Court opinions that may have implicitly held this. But unfortunately for the cable giant, Wu seizes on one 2007 opinion from the Ninth Circuit that rejected mixed motive. And like fundamentally, when you think about mixed motive, here you have a way that law developed. So if I have a reason not to do business with you, you late, or let's not even deal with something like that egregious. If I have a reason not to do business with you, I prefer green widgets over brown widgets. You keep bringing green ones. If I also am not doing business with you because you're black, you can know that I'm not doing business with you because you're black, and because I have a legitimate motive, that mix of those two motives still gets me through as being okay. So in effect, instead of me not doing business because you're black, tainting my belief that I want brown widgets that you don't have, not wanting your green widgets, it actually just erases the racism. So my good grounds erases racism versus my bad racism erasing good grounds. And that doesn't make any sense given the history of this country. That basically shuts the door on black people being able to bring these lawsuits. Well,
I think you're exactly right. I don't think people realize that like this racism is legal. And there's no way to stop that. If they can say anything, you can say, well, it's just not the right time. That's what you can say. And you can still be racist and say it's not the right time. And I can know you're racist, but hey, he had another motivation. So that makes racism just legal. And the one thing I keep hearing as Obama comes towards his end, people say, well, he appointed some black judges and he appointed some minority judges. It's not clear. Like, let's be clear. When I talked about Judge Hatter a minute ago, it's not clear that appointing more black judges is necessarily good for black people, depending on who those judges are. This judge that in this case sided on behalf of Byron Allen was not a black judge. So this idea that, it's necessarily a good thing just to be a black judge without looking at that judge's ideology, looking at his previous cases, it just seems to turn that on his head.
No, I have to agree to that part. I think that we got to look at people individually, and we as black people need people that are far left as possible, so that they can begin to get back to the historical context that allowed for the civil rights movement to develop. Not center left, not just left. We need to look at and ask for people that are far left, and that's almost regardless of race. I think that I have to agree. Black America right now possibly is ignoring, and I'm not saying that nobody knows what's going on, but this is a moment to really get behind something. Black America is ignoring the biggest civil rights case in 50 years if we don't cover and push this appropriately. Again, I appreciate everybody tuning in. I'll give Yvette the last word.
No, I think that this is an opportunity to blow that section that you referred to wide open. That section of law was intended for us to take advantage of it. And if Byron Allen is successful in taking advantage of that section, then we could be successful in taking advantage of that section of law in other areas in terms of accessing capital. So I think it's disappointing to me that more black people aren't following this case and pushing this case forward and putting pressure on this judge, because when we get together and put pressure on people, we can, because then we will be able to use that law to access capital and say you can't just do this mixed motive thing and be racist. Like we can't do that anymore. So I think I really want people to, one of the things that you have to do in terms of a movement, you have to start following what's best for you in terms of law, in terms of winning cases, as opposed to who you like individually. So it doesn't matter if you like Yvette individually. It doesn't matter if you like Antonio individually. It doesn't matter if you like Byron Allen individually. This law, if Byron Allen can blow this open, if we can get some rulings, this law could be good for us. And I think we need to start thinking. People talk to me about collectivism when I talk about black wealth. This is a time for collectivism right here.
Yeah, I agree. And again, make sure you subscribe on Tone Talks. Subscribe to Breaking Brown. Thank you so much for your support.